Uh, is my screen is visible? This
Yes, yes,
patent
it
rules
is.
2003.
It is.
So, in the rules or the patent rules 2003, there are the rules having a maximum of the timelines and forms and fees. So the things which are required very precisely, those things are given into the rules generally, or some procedures are there, which all the things which are given into the rules with respect to the sections. So the things which are given into the sections, they have given the basic idea about the different procedures, different concept over there. But with respect to that particular concept, which forms are used, which what is the fees for that, what is the timeline for that, or what is the procedure for that. So those all the things will be covered into the rules, and rules can be easily amended. So the multiple time, if you will see that the multiple time amendments will be there in the rules, and the timelines which are given into the rules, that there are flexible timelines and that can be amended at the time of the amendment. Any of the amendment will be there, then that can be amended. So in that, there are total 16 chapters are there, which covers the rule number 1 to 139. So in that, quickly, if we are going move for these rules, so in that, first one is related to the preliminary, means that is related to the basic details about the patents which are not given into the sections or the patent act. So in that, the rule number 1 to 9 will be there. Then in the rule number 9, they have given the basic details that the sort, title, and commencement means the these rules we are pronouncing the patents we are adding here as patents rules 2003. So that is the detail given into the rule number 1. Then the few definitions which are not covered into the sections, that will be covered over here. Then the prescribed particulars means some of the particular, in the sense some of the forms which are used, the details they have given over here. Then the appropriate offices. So generally the total 4 offices are there, in which we have to file the patent application, and all the patent related procedure will be there. So there are four appropriate of that 4 offices are Mumbai, Kolkata, Chennai, and the Delhi. So now how the applicant will decide whether they have to file in the which patent office. So that details they have given into the appropriate office, that they have given some of the options over there, that based on the address of your business, then based on where your research has been come out, then based on the applicant's residence. So based on these different criteria, any person or the applicant can choose any appropriate office. So generally the Delhi covers the whole the north region, then Chennai covers the south regions, Kolkata covers the rest of the India, which are not covered into the any of the three, Mumbai, Delhi, and Kolkata. Then in the Mumbai, they are covering generally the Mumbai, Rajasthan, and any other the nearby states. So that first we have to decide that which we are from the which state, we are from which state, or our research work from the which state, or the business address, or the address for the patent agent, that is the appropriate address is from which state, and based on that the appropriate office will be selected. So that already I have said that which states are covered under the which offices. Then second is the address of service. So generally address of service means the each and every communication has been done from in between the patent office and the applicant or the inventor, that will be communicate on the address of service only. So that will the address of applicants may be vary. If the more than 1 or 2 applicants are there, then address of inventor may be vary based on the number of the inventors. But the address of service we have to keep the fixed for the each and every forms, and on that service address our patent office will be communicate. So generally if you any person who is hiring the patent agent, then generally the address of the patent agent will be become as a, or the law firm address of the patent agent will become as a appropriate address or the address for the service. Then leaving and serving documents. So which documents we have to submit to the patent office in the hard copy, which if we are submitting some of the documents in the soft copy or uploading soft copy, then it's okay. So this if we are submitting, what is the timeline for that? Once you will file the patent application, then within that 15 days of the period, you have to submit the original documents to the patent office. Then the rule 7 is related to the fees. Fees means the each and every fee related structure which are related to the each and every activities. So the all the fee structure which are given into the schedule and schedule 1 and 2. So in the schedule 1 that is related to the fees, and schedule 2 is related to the forms. So this rule number 7 is related to the fees, and rule number 8 is related to the forms. Forms means each and every forms which are used for the different activities when we are applying for the patent from the starting from the application to the grant. Then the rule number 9, the filing of the documents and copies. So similarly, how we are filing the documents, either in the way of the online mode or the offline mode. So the in general basic details about the patent law which are not covered into the sections, that will be covered into these rules in the chapter 1. Then coming to the chapter 2. So in that, the things which already we have learned into the sections means how the patent application look like, which parts they have covered, what is the different things which we have to add it into the form 2 or the complete specification. Those whole things or in detail they have given into this chapter. So in the rule number 10, they have given detail about the period within which the proof of right we have to submit. Proof of right means the generally the form 1 will be there used as a proof of right, but if the form later on stage, if any applicant will be added, then we have to submit the deed of assignment and all. So that become act as a proof of right, and that we have to submit with the application only, or within that 1 month period we have to submit that proof of right. Then the rule number 11, ordering of the recording application, how the application will be recorded, or how the numbering will be given. So for that the numbering system will be there. So since few years ago they have amended the numbering system. If previously you will see that there is some number, then oblique, then the patent office designation, like which patent office is there. The patent application filed is where Mumbai, Kolkata, Chennai, Delhi, then the year. So that is the old format. Now that format will be changed by the only the numbering system. So that numbering system I have also shared with you in the material related mails. Then third one is related to the section 8. In the section 8 they have told about the form 3, and the section 8 which related to the foreign filing. If you are filing any application outside India, in any time after filing the patent application in India, that you have to inform to the patent office. So for that section will be the 8, form will be the 3, and the rules will be the 12. So that 6-month timeline will be not given into the sections, and they have given their timeline into the rules. So generally rules covers the timelines, forms, fees, and the procedure. Then basic details they have given about the whole the form 2, how the specification will be there with respect to the sections also. Sections also given some of the details about the form 2, but with respect to that, rules have given the much more detail about that. So rule 13 is related to the specification. Then rule 14 is amendment to the specification. How, if amendment, any type of the amendment will be there, so how it will be there. Then the rule number 15 related to the drawings and the models. So in the drawings they have given the one as I have teach you in the last lecture related to the patent drafting. So how the drawing set will be look like. So it is in the A4 size paper. In the right hand side left hand side top corner, we have to write down the each and every the name of the each and every applicants. Then in the right side top corner we have to write down the seat number, and the right side bottom corner we have to do the signature, right? So that things we they have given into the drawings and the models. So models are not the part of the specification, and we no need to give the model with the each and every application. But if the control will ask for the model, then we have to submit those, but that is not a part of the specification. Then this is related to this chapter 2. And third one is related to the whole the rules starting from the rule number 17 to 23 that are related to the PCT. PCT means the one type of the international application which is filed under the Patent Cooperation Treaty. So this PCT, what is the full form of the PCT is the Patent Cooperation Treaty, and for that the WIPO is the organization, World Intellectual Property Organization, which is based on the Switzerland, where we have to file the PCT application. So that is the one type of international application. So for that, where we have to file, what is the how many copies are required, where what is the procedure for that, what is the flow chart for that, how what is the international search report, what is the international preliminary examination report. So each and every details about those things which are given into this chapter related to the PCT. I have conducted the whole the separate section session for that PCT, which I have already said to you all in the recorded sessions. So once go through that, if you will feel any query in that PCT related chapter, so you can ask me at any time. But this is also a very important chapter. That is all the flow will be there. Based on that flow only, they have mentioned the rules over here. Then coming to the publication and examination, the previously we have learned about the filing and the drafting, right? In the previous chapter, then the PCT related. Now, once the patent application will be draft and filed, then what is the next step? Next step will be the publication and examination. So those things, the related to the publication examination, they have already given into the sections. But which forms will be used? What are the timeline for that? That's all the things they have given into this chapter. So this is related to the publication. The journal publication will be the published within in the after the 18 months from the first filing date. But in that they have given the sub rule, that rule number 24A, which is related to the request for the publication, means that is particularly related to the early publication request, in which form 9 will be used and the publication will be published within the month. So that is the timeline and the form for the early publication. For the normal publication, there is no need to pay any extra fees or no need to file any extra form. And then coming to the examination, so in that the 24B and C will be there. So the 24B, which is related to the examination or the normal request for the examination, will be there. For that, form 18 will be used within the 48 months from the first date. We have to file the request for examination. And in the 24C, they have given the criteria for the expedite examination, who is eligible for the expedite examination, what is the form. So the form 18A will be used for that. Then the timeline will be the same, 18 the 48 months from the first filing date. And who is the eligible? So any female candidate from the applicant list, if any one female candidate will be there, then that those applications are eligible for the expedite examination. Any startup, for the small entity, or any education institution, or any international application who is filed under this Paris Convention or the PCT. This all the applications are eligible for the expedite examinations. Then the identification of the published applications. So how you can identify? So for that they have given the number and what things will be published into the journals. Every Friday journal will be published by the patent office, and in that application will be published. Then the request for the withdrawal. So in that, if you have filed the request for examination and in later on stage you come to know that some of the very close prior art will be there, and you want to withdraw your application or the request for examination. So for that you have to apply that for the request for the withdrawal, and for that you will also reimburse the amount of the that form 18 or 18A. Then inspection and the supply of the published documents. So if anyone wants to go to the patent office and want to check or inspect the documents, so what is the procedure for that? Then the procedure in case of the anticipation by the prior publication. So the basic details related to the prior publication they have given into sections. Now what is the procedure for that? That those things they have given into the rules. Then the procedure for the report of the examiner under the section 14. How that report they have generated. For that the procedure they have given, what is the timeline before that, when the that particular patent application will be given to the examiner, then within which how many months they have to generate the examiner's report, then within how many months the control will check that report, and within the how many period the control will dispose the report to the applicant, then within that how many period the applicant has to reply. So the whole the timelines they have given into this. Then the procedure for the anticipation by the prior claiming. First, this is related to the prior publication, then prior claiming, then amendment of the coverage specification in case of the anticipation, then the form for the reference of the another specification, if any, which forms will be used if you are referencing, if any relevant prior art will be there into the examination time, and if you are removing some of the part and by the amending your application. So in that you have to give the reference of that particular prior art. So for that how you are giving that reference into your specification. Then what is the procedure for the potential infringement, then form for the reference of the another patent. So this is related to the specification, means before grant procedure, and this is related to after grant procedures. If you are adding or amending your application, patent application or the granted patent by way of by removing some of the part which are already disclosed and by giving the reference of that particular part. So for that they have given the different rules for the specification as well as for the patent. Then for the manner in which under the section 21 shall be made, that the things they have given the manner in which a request may be made by the 24. So in the section 20, which is related to the substitution of the applicant, right? So if any time substitution will be there before grant, after grant, so what is the procedure for that? Then manner in which this is whole related to the section 20, so in which the substitution applicant will be there. So in that different procedure for that. Then the numbering of the application of the grant of the patent. So how you can identify that is given that the numbering system that is for the patent application. Now the numbering system for the granted patent. So the number which are given at the time of the filing, that will be changed at the time of the grant, and at the grant of the patent application the 6-digit number will be there. Then the chapter 4 will be omitted. Coming to the chapter chapter 5 will be omitted. Chapter 6 related to the opposition. So the opposition related things which we have learned into the sections. For that the different procedures are there, how the opposition will be conducted in the patent office, what is the procedure for that, that whole the process they have given into this. So this is relevant to the pre and post grant opposition and any other opposition which are filed against the surrender, revocation, or patent of addition, or any patent amendment. So any the normal opposition which are filed before grant or the after grant, and with that also any other type of opposition, for that the same procedure will be followed. One of the opposition chart I have shared with you. With that, if I will some other details are required in that chart, so I will make those chart and again share those things with you. But the chart which covers the whole the procedure for the opposition, that I have just shared today morning only. So you can refer that those chart for this whole the procedure, how the board will be formed, how the document will be exchanged, what form will be used, that all the things they have given into the this chapter 6. Then this is related to secrecy direction. So as I have told that the some of the defense related dimension will be there. So for that one whole chapter in the patent act will be given for the secrecy direction, that will be covered by the hemaxid by tomorrow or the day after tomorrow, and relevant rules will be given into this chapter 7. Then the grant of the patent. So in that form for the patent, then if the earlier the will be the inspection of the documents related to the patent application, now the inspection of the documents related to the grant of the patent. If any amendment will be there, then there's some of the direction which are given into the section 51. For that the relevant rules will be given over here. 51 means the co-owner related rights are there, in that the control power of the controller with respect to the co-owners. So generally the owners have, each and every applicant having the equal rights, equally undivided rights will be there. But if in some case, if any dispute will be there between the co-owners, then the control will guide them and give the direction for that. So related for that, how the control will guide them, for that the procedure will be given over here. Then how we can pay the renewal fees. So the renewal fees related details will be given in the section 53, and relevant rule with the rule 80. Then the amendment of the patent application specification, any other document relating that to. So the amendment related to whole the chapter will be given into the sections, that the CDE, disclaimer, correction, and the explanation. In these three way we can amend the patent application before grant, after grant, and to the appellate board they have given the amendment into the sections. Now here what they are telling, that how we can amend the things, that there are more details they have given over here. Then the preparation of the amended specification, publication of that amendment is allowed. So the things which are amended, that will be published or not, or published, so where published, the whole the things they have given in the chapter this 9. Then in the chapter 10 they have given the details about the restoration of the patent, which forms will be used. Then if the restoration has been done, then from the date of the cessation to restoration, in between, if any rights will be there or not, what is the grounds are used for the restoration, and if you have applied for the restoration, then if any person wants to file opposition for that restoration, then what is the procedure for that. And the payment of the unpaid renewal fees, so the payment, how they have to pay, they have to pay the restoration fees also, with that also they have to pay the pending renewal fees also. So that those details they have given into the restoration related chapter. Then the surrender of the patents. So if anyone wants to surrender their patent, in that they have given in this chapter. So today we are trying to cover that revocation as well as the surrender. So at that time we will cover this rule 87, which are related to the surrender. Then the register of patent. So what it will be contained. So in that the register of patent under, they have given the which details are given into the register. Then the title and interest of the patents they have given. Then if any assignments will be there, that those things are also over there. Then the entry of renewal fees will be there, alteration of the address will be there. Then if anyone wants to inspect that register, and then for that also they have given some procedure and the fee structure and the forms for that. And coming to the chapter 13, which is related to the compulsory licensing and the revocation of the patent. So in that, which form will be used, then what is the prima case will be made or not. In that also, if the opposition will be filed, then what is the procedure for that. Then publication of the revocation order, if the revocation will be there based on the non-working, then application under the section 84, then procedure. Then the application for the termination of the compulsory license, which form will be used for the termination, what is the timeline for that, what is the fees for that. This whole the things they have given in this chapter related to the compulsory licensing. Then the scientific advisors, as I have told that for the infringement related things, the court or judges will appoint some of the scientific advisors to guide them, because the judges are from the law background, and generally patents are related to the technology and the pharmaceutical background. So judges cannot easily understand the what exactly the things are in the patents. So for that they will appoint the scientific advisors. So for that they have given the details, hold the details over here. What is the qualification for that, what is the role for the scientific, what is the disqualification for that, what are the power for that, if their name, how their name will be removed, based on which type of the discrepancies. Then how their name will be included in this, whole the details they have given into the scientific advisory related chapters. Then the chapter related to the patent agents. So in that they have given the which type of the documents we have to given when we want, if we clear the exam and we want to add our name into the patent agent register, then what are the documents for that, then how we can apply for that, what is, which form will be used, then what is the qualification criteria for that, how we can register for the patent agents, how we can register for the patent agent examination. Then if anyone wants to issue the duplicate certificate for the patent agent, then how, what is the procedure for that. Then the details includes in any application for the registration of the patent agent. Then what is the disqualification for that, how the payment will be there, if the name will be removed, then how it's on the which grounds name will be removed, then how we can restore that names, then alteration, if any alteration in the name, then how we can do that procedure. Then refusal to recognize as a patent agent, for that they have given some of the criteria. And the publication of the name of the patent agent, the how, where it will be published or where it will be available. So that those things they have given into the patent agent chapter. And in the last chapter they have given the things which are not mentioned in any of the chapters in the sections as well, and in the rules they have given some of the miscellaneous rules are there, which are period within which the copy of specification we have to file, then address of communication, correction of any clerical error, then a manner of advertisement of the proposed correction in the any error, then the manner and time for the opposition for making the correction, notification for the correction. So this is related to the basic correction related things. Then exhibits, if then affidavit related things. This is related to the hearing. If you want to adjourn your hearing or delayed your postpone your hearing, for that what is the procedure for that? Then the whole the miscellaneous chapter is still pending for the regular batch and for the crash course also. So that me and Hemaxi will cover by the next next weekend. So at the time you will get the more idea about the each and every rules which are covered under this chapter. Then the first schedule is related to the fees and second schedule is related to the forms. So in that also, with respect to the rule number with the title, you have to remember for the each and every sections number with the title and each and every rule number with the title. With that also, you have to remember the each and every forms. What is the form 1? For that the title you have to use, where it will be used, that also you have to remember. Then relevant fees you have to remember by referring this schedule 1. And they have also given the forms over here. That form 1 is the basic form which is used for the filing of the patent application, which covers the basic details about the applicants, inventors, title, the number of the pages of the complete specification, then address of services, contact details, patent agent's address, everything, the basic details about the patent application as well as the applicant and inventor, that will be given into this form 1. Then form 2, that is the basic, that is the actual form in which we have to add the whole the technical write-up or the patent drafting we have to do into the form 2, either is the provision or the complete. Then form 3, which is give the details about the foreign filing. Form 4, if you want to extend any of the timeline which are given in the Patent Act, then you have to file the form 4 to extend those timeline. Then form 5, declaration as the inventorship. So if the inventors and the applicant will be differ, then inventor has to sign this form 5, and that will be filed with the complete specification or within the 1 month of that complete specification we have to file the form 5. Then form 6, if any change in the applicant. Then form 7 is used for the opposition, that is used for the post grant opposition, pre grant opposition. And the 7 is used for the representation of the opposition for the grant of the patent, means the post grant opposition. Then form 8 is also is used for the mention of the any inventor. If anyone wants to add their name as an inventor, then after the filing of the patent application, then form 8 will be used. Then form 9, as I have told, that is used for the early publication. Form 10 used for the amendment. Form 11 used for the direct. If anyone wants to take a direction from the control side for the corners related dispute, and also form 11 will be used. Then form 12 will be used for the grant under the 26 and 52(2), means the application will be wrongfully obtained from the inventor. So in that case, inventor will be asked for the patent application. So for that, this form will be used. Form 13 will be used for the any type of the amendment. If you will carry, form 14 will be used for the opposition. Sorry, with respect to the amendment, restoration, surrender, compulsory licensing, or any of the things which procedure has been done. And for that, and if any person wants to file opposition, for that form 14 use. Form 15 will be used for the restoration of the patent. Form 16 will be used for the addition of the, if any assignment or proprietorship will be there, if the patent will be granted on the individual name, and after in the later stage, individual person will assign his or her rights to the any other companies or any other form. Then at that time, that assignment will be given in the form of the form 16. Then form 17 for the compulsory license. Form 18 for the request for examination. Form 18 for the expedient examination. Form 19 for the revocation on the grounds of the non-working. Form 20 for the terms and condition of the license. If anyone wants to revise the terms and condition of the any of the license, either compulsory or the voluntary license, so for that form 20 will be used. Then form 21 for the request for the termination of the compulsory license. Form 22 request for the application for the registration of a patent agent. Once you will clear your examination, after that you have to file the form 22 to add your name into the patent register. Then form 23 for the restoration of the name of the patent agent. If the patent agent's name will be removed from the register, then how you can restore their name, by the way of the form 23. Then in the form 24, application for the review and setting aside for the control's decision. if anyone wants to review that decision or file against some counter argument against that decision, then for that the form 24 will be used. Form 25, if anyone wants to directly file the patent application outside the India, for that they have to file the form 25. Form 26 for the power of authority. Form 27, that is every year the patentee has to file the form 27 stating that the working of the patented invention, whether it is in the working stage or not. Then in the form 28, that it will be filed by the any startup, small entity or the educational institution. Then form 29, request for the withdrawal of the application. For the the request for examination can be withdrawn. For that, form 29 will be filed, and if any of the procedure in that any form is not mentioned at that time, you can refer this form 30. Is this clear? This the quick summary for the whole the rules.
Yes, yes. Quite clear.
Okay, then just a minute.